Okay, we are recording now. And I am going to spotlight your camera. There we go.
All right, Jackie, you let me know when it's time to go. I think you wanted to wait a few minutes, so you just let me know when it's time to start.
Okay, I want to make sure that we're cautious of everyone's time. So Lori, if you are ready to begin, I'll let you go ahead.
Okay, well, good morning, everybody, and nice to have you back to our third session of Legal Matters. I'm excited to talk to you about our next scheduled topic for today. And I know that Jackie has mentioned this before, and I just want to make sure that we are all aware. If you would like to ask questions during this session, I know we're not sitting face to face like we normally do in the Jacksonville Women's Business Center. So if you'd like to ask a question, just go ahead and type it in the chat, or actually in the question and answer section, which would be easier. So if you hover over that controls, you'll see a Q&A. If you want to type your questions in there, Jackie will help me monitor those so that I don't miss those. And then I'll try to check in and just to make sure we're not whizzing past some of the questions as we're talking about those topics. Okay, so let's get started for today. Introduction for those of you who are just joining us. My name is Laurie Lee. I am a business attorney. And for the past almost 18 years now, I've helped hundreds of small business clients protect their business and grow their businesses stronger. So what we're talking about today for Legal Matters is we are performing a self-audit over the course of 4 weeks. And so today we're going to be talking about new topics for your audits. And before we get started, just a reminder that there are 2 types of business owners, and keeping in mind which type you are. Of course, the flyers, as we've discussed, are those that jump off the cliff and build the plane as they learn to fly. And if you are one of the flyers, then that's okay, because now you're circling back and you're plugging in the holes and you're building that stronger plane. And if you're a grounder, that means that you like to start from the ground up and you get to the sky by growing the tree nice and strong and steady. And if you're a grounder, then you want to know all the information to do something before you do it and take action. And both types of business owners are perfectly legitimate. They're successful, both types. So there's no judgment. It just, how you function is important to understand so that you know where you are in your stage, in your process, so that you know when to come in and kind of take a look at some of these things we're talking about. In any case, as your business grows, you need a stronger plane. And so as you add more employees to your plane, as you add more workers, as you add more clients, your plane needs to be stronger in order for your business to grow. And if you start to lose altitude, that means that your business isn't strong enough to sustain that weight. So what we're talking about then is building your business stronger. And this is our infrastructure map that we've been working off of for the whole class. And this shows you all the different pieces of your business where legal issues come into play. So in building legal infrastructure for your business, what this means is all these different pieces are the areas where you're going to have to focus on at some given point in time. So it's kind of like whack-a-mole. One piece comes up, your attention goes to it, that one goes down, another piece comes up. It's never a matter of getting all the pieces settled down and then they just stay there. Things are always popping up. So as your business grows, as your business changes, as you're doing things differently, you always have to circle back to these things. So I want to make sure that your mindset is in the right spot, because for now, you might say, you know what, we covered entity structure and I'm good on that. Everything's nice and clear. But 6, 8, 10 months from now, that doesn't mean you need to go back and make sure it's still okay. Because as your business is changing, then that means that you have to come back and make sure that there's nothing else that you need to do to put in place. So let's talk a little bit about what we've covered so far, and I'm happy to take some questions if you have any before we jump into new content today. So our first class, we talked about the green at the top up here, government regulations. We talked about entity structure, and I gave you a self-audit sheet to go through a questionnaire, whether you're a corporation or an LLC, and we talked about the differences and all the pieces that go into that. We also talked about regulatory compliance, which is the government rules and regulations that they impose upon businesses, all different levels, all different types. And then last week, we talked about external relationships, which we talked about client relationships and clients or customers, whoever you call them, patients, whatever they are, whoever you serve. Having good relationships with them is really important to the success of your business and the stability of your business. On so many reasons. And we talked about the front facing part of your contract, or your relationship, which is making you money. And then the backward facing, the backside, which is protecting yourself and saving yourself some money and trying to avoid problems. Again, the whole point of this is to try to avoid problems, number one, from even happening. And then if they do happen, the problems do happen, then you want to minimize their impact. So you have things in place that say, you know what, I can handle this. This isn't going to take down my business. Understanding that small businesses don't have as many resources as big businesses do. So even, a smaller size wave can kind of drown us. So we want to make sure that we have all these things in place so that if those problems do come, we have the structure there to handle that. And then we also talked about vendor relationships and how vendors serve our businesses and how we manage them and how we establish our relationships with them. And we talked about the importance here of reading the contracts that you have with your vendors and understanding your relationships and your obligations on both sides. And then understanding how that relationship benefits your business and whether or not you want to continue it and terminating those relationships and so forth. So hopefully right now you are halfway done with your self-audit because we are halfway through our infrastructure map. So hopefully you've gotten 4 self-audit sheets done and you have them filled out and you have indicated on them where you want to do some improvements. So last time we have client relationships, vendor relationships, and I want you to go in and calendar. I know you've already calendared those for your entity structure and your regulatory compliance, but calendar when you're going to do these things. It can be a little overwhelming going through and doing all of these things and seeing all these pieces of your business that you need to pay attention to. I know it is for mine. We're a small service firm as well. And so there's always things that can be done on your business, in your business. Just make sure that you put them on your calendar and circle back to them. Don't feel like it all has to be done right now. Our purpose for Legal Matters is to pull your attention to it and to say, this is an issue and put it on your to-do list. It doesn't necessarily mean that you have to tackle all these things right now. So my point for you is to put them on your calendar. Don't ignore them because we know what happens when you ignore issues, right? At some point in time, they're going to jump up and bite you. And the bite is going to feel a whole lot more painful if you're not prepared. So make sure that you put them on your calendar and get that going. All right, so we have a question so far. Will you be addressing NDAs, confidentiality provisions, or non-solicitation agreements? Yes, I will. That's actually on today's topic. So internal relationships is our big area for today. We're going to talk about owner relationships. And some of you might be the only owner in your company, and some of you might have business partners. And so those owner relationships are what we'll talk about today first. And then we're going to talk about worker relationships. And by workers, I mean your employees and your independent contractors. We'll talk about all of them together. All right, so we're going to go ahead and get started with owner relationships. And if you have, I know that it looks like there's 9-10 people on here right now. If anybody has a business partner and you're willing to tell me that you have a business partner, if you could just put it in the chat. I'd like to see how many of you have business partners, so I can kind of tailor what I say towards people either who are the only owners of their business, or if you have a business partner. If you're willing to tell me that, that would be fantastic. All right, so I don't see anybody chatting, so I'm going to make an assumption here that those of you who are on here are all single owners. And so I want to make sure that what I go over here is I'm going to skew it a little bit towards those of you who are single owners. And yes, some people are considering on bringing a partner, which is how I'm going to address this topic. So for those of you who are just basically the captain of your own ship right now, what does that look like to have a business partner? And I will tell you, for the past 8 months, I've been dealing a lot with my clients on ownership changes. And whether that's with partners leaving or businesses combining forces and partners joining together. And maybe that's because of economies of scale, where you're trying to combine overhead costs and save some costs there and efficiencies. Or maybe it's just sharing the responsibility in uncertain times. Maybe it's a way of expanding your business and you say, look, I do this, you do that. Let's combine and we'll have a bigger, better business. That happens all the time. I can say that's happened a whole lot more frequently this year it's always there, but I just see higher numbers with that right now for 2020. And I think that's understandable. People, making changes, trying to adjust to the economic circumstances. So I will tell you, with owner relationships, I say it's like a marriage, but without all the fun stuff. Because as business partners, there's not a whole lot of that fuzzy, lovey feeling that marriages have, but the marriage, all the stickiness and the intermingling and with funds and decisions and responsibilities, all of that is there. So business partnership is not an easy thing. It is very difficult. And so I want to start by going over what the law says for business partners. And these are what I call the default rules. So this is what happens. These are the rules that every business partner has to live by. Okay, this is, unless you change them, and we're going to talk about how you change them. Okay, so these are the default rules. Number one, you can only be changed by written agreement, which we're going to get to that. Owners are not required by law to work in the business. So an owner can quit working in the business and still be an owner and still get his or her share of the profits. So that might be of concern, because sometimes, I have clients that come to me and say, you know what, I need help in the business. That's my biggest motivation to bringing on a business partner, is I need help. And I say, bringing on a business partner doesn't guarantee you help. What it does guarantee is that you will split the profits with somebody. So it is not necessary for business owners to work in the business. So they can quit. That's the default rule. There's nothing you can do to stop it unless you have a written agreement which we'll talk about. Second one, the law does not place restrictions on how and to whom an owner can sell his or her share of the business. So an owner can sell his or her part of the business to anyone at any time. So your business partner can sell to somebody you don't know, and then you are in business with somebody you don't know. So that is the default rule. It's property, just like anything else. It's a car. It's, 50% of a business, 40% of a business, 10% of a business. It's property, and they can sell it to whomever they want to sell it to, whoever will pay for them, and whoever will pay whatever price they negotiate for them. So a lot of times, some of our tech companies are really concerned about the valuation of their business. And so, when you sell you sell some shares or interest in your business, that can set the valuation price. And, if your business partner goes out and just, takes $100 for it just because they want out, that's not going to be good for the valuation of the company. But it's also not good because, you might not know the person they sold to, and then you're in business with somebody you don't know. And that's never a good situation. If an owner gets divorced, the divorce court judge has the authority to distribute the ownership of the business to the ex-spouse. This can happen when the property is divided up. So when people are married, they gather, they purchase property together. And so when they get divorced and they split up, the judge, divvies it out, right? So a business could be caught in the middle. And they could say, you know what, you get the house, well, you get the business. And so that is always a risk in family law court when you have divorce, even when this is the case, even if the wife is the one on the business, the husband had nothing to do with the business, isn't even on the business as an owner, this can still happen. So be aware of that. You don't have to have the husband and wife or both spouses, whoever they may be, on the business for this to happen. So that's one of the reasons why when we have business partners, we say you could potentially end up in business with your partner's ex-spouse. You may or may not like him or her, but that's always a possibility. And then upon an owner's death, the ownership in the business passes to his or her heirs. So again, just like property, the ownership of the business passes to whoever the heir is of that business owner. So if the business owner has a will or has a trust or whatever that might be, then their will dictates who their ownership goes to. So it could be their spouse, it could be their nephew, it could be their grandparent, it could be anybody who they say in their will. If they don't have a will, then the laws step in and say who it goes to. And that's called intestate. And the intestacy laws say it goes to children, it goes to spouse, it goes to parents, it could go to brothers and sisters, depending on the situation. So that's difficult. And I've actually had this situation, unfortunately, several times over the course of my career. And when somebody's not involved in the business, and one time it was a spouse, and the other time it was a child, it was a son, a grown son. Neither one was involved in the business, and they thought that the business was worth a ton of money. They just thought it was so profitable and worth a ton of money. And then, and then my client, who is the surviving business owner, tries to buy them out. They were asking, an unreasonable amount of money because they thought it was so valuable. Well, it wasn't that valuable. And it was a difficult conversation because they had just lost their loved one. My client had just lost a business partner. And now we've got this ownership instability going, which was not good for the business in either case, because all the attention was going towards losing the owner. And then, the ownership not being stable caused the business to lose some traction, lose some altitude. And so that wasn't a good thing. So moving on here, the next default rule, with certain titles, an owner could have the authority to make decisions and sign contracts on their own without consulting the other business owner. So titles matter in a business. So, if you have a title of a president or whatever the title might be, CEO, COO, whatever it is, the title could give the owner the ability to act alone. So instead of coming together and discussing and making decisions together, one owner maybe could have the authority to go out and act by themselves. And then once it's done, it's very difficult to undo. You can't just run out there and say, "Hey, well, wait a minute, we're gonna undo that transaction because I didn't have an input into it." That other party is going to be like, "I'm sorry, this person has the right title. I'm dealing with this person as the representative of the business. You can't undo it." And so that could cause the business to kind of enter into expensive or detrimental contracts, and there would be nothing that you could do about that. If an owner files for bankruptcy, his or her ownership could be given to creditors to satisfy debts. And that is a very real risk that trustees in bankruptcy divide up assets. And sometimes businesses are assets and they could be given to creditors. And then you're in business with some bank or lender or whoever it might be. If an owner becomes incompetent, his or her ownership in the business is controlled by a guardian. And this is true for any age. It's not just for elderly owners. Car accidents, illnesses, anything that could happen to anybody at any age. If the court appoints a guardian to oversee that person's life, health decisions, financial decisions, property, everything, the business comes under that umbrella as well. And then whoever's on the bank account has the right to withdraw and deposit money. And so this is one that we go over. All of these things are ones that we go over in our door number 4 program quite a bit, because these are little details that business owners tend to overlook until there's an issue. And so monitoring who is on your bank account is really important. And by bank account, I mean business bank account, not your personal. I'm always talking about the business bank account. So how do you overcome these default rules? If you don't like one of them, or if you don't like all of them, you have a partnership agreement, and that changes the default rules. So that is the only way you can change the default rules, is if you come in and you both, or all of you, I have clients that have multiple owners. And so all of them sign a partnership agreement. And I use the word partnership agreement a little loosely. So let's talk about that for just a second, because most people tell you, "Oh, I have a partnership agreement." It's never really a partnership agreement. Like in law, we have official titles for things, and we very rarely call this a partnership agreement. So let's talk about what this agreement actually is called for you. If you are an LLC, then your agreement would be called an operating agreement. In LLCs, there's one agreement, one contract for the whole company, and it's called the operating agreement, and everything gets put in there. It's like the kitchen sink. Everything gets put in there. So it's not only the things we talked about. Remember when we talked about entity structure and we went through all those different things? It has that stuff in it, yes, but it also can have these types of things. And these types of ownership issues, what we're talking about here is called buy-sell provisions. So if your operating agreement has buy-sell provisions in it, some of those default rules would be overwritten. We also put management and authority provisions in the operating agreement that says, how is a business partner supposed to make decisions? Do they have to come to each other and discuss it and make decisions together? Or do they have the ability to make decisions? So this partner makes a decision for these types of decisions, and this one has responsibility for these kinds of decisions, and they kind of operate in silos independently and only coming together for certain other types of big decisions, which all of those ways work. It's just figuring out which way is the best for your situation. And then it gets put into an operating agreement. For corporations, it's a completely separate document, and it's called a shareholders agreement. because remember when we talked about the owners of corporations are called shareholders. That's the terminology. So the shareholders agreement is the agreement that deals with all the ownership pieces. Partnership agreement is the only official term if you actually have a partnership. You don't have an LLC, you don't have a corporation, you have a partnership. They are very, very rare these days because it is a very old form of doing business that is no longer beneficial in most circumstances. So typically we don't see general partnerships. I don't think I have ever seen one in my, 17 years of practice. I've never seen a general partnership. I have seen a limited partnership. And those typically are for real estate developments that are really complicated, and the partners are not people. The partners are other LLCs and corporations, and there's multi-layers of that business. So generally speaking, we don't do partnership agreements, although that's just what people call them, and that's okay, as long as you know that the real term is operating agreement or shareholders agreement. Sometimes if you have just buy-sell provisions, it could be called a buy-sell agreement. So let me talk about that for a minute, because a lot of bankers use this terminology. They say, do you have a buy-sell agreement? What this means is it's a very limited agreement and it only covers certain things. So it doesn't cover all those default rules we just talked about. It only covers the default rules that pertain to death, incapacity, divorce, bankruptcy. So those are the pieces that the buy-sell agreement covers. It's meant, what the buy-sell agreement, the title means that when must you buy and when must you sell as a partner, not the whole business, your own partnership ownership in the business. When must you buy, when must you sell? That's what this is. It's not when you sell the whole business to somebody else. So that's the terminology for the agreements that you would need to override the default provisions, the default rules. So what is the best time to do an ownership agreement? Anybody have an idea? When do you do this? When everything is perfect and you're getting along well. That's the only time you can do it. So it doesn't necessarily mean you need to do it beforehand, like before you become a partner. And I know some of you are thinking about bringing on a partner. You can do it then. That's the ideal time is, as you're putting your partnership together, that's when you do the agreement. But sometimes with the flyers, they've already jumped off that cliff and they've already, they're trying to build that plane. And so they already have a business partner. And so the best time then is not to wait until there's a disagreement, because as soon as there's a disagreement, the time has passed. It's very, very difficult to put together an ownership agreement once conflict has come up. It's much, much better when everything's perfect, you're getting along well, it's all roses, everybody's optimistic, you're all on the same page, everything's fantastic. That's the best time to put it in place, because it increases your chances of keeping everything on that even keel. Because what happens? We are human beings, right? And as human beings, we come with all kinds of emotions. And emotions tend to fluctuate. They are not stable. At any given day, your emotions are going to be different. And this is just how we are as humans. And when you interact together, emotions drive behavior. And behavior then creates emotions in other people. So I know I'm talking psychology, but you have to understand that psychology plays a huge role in law, in business law. Psychology is a huge driving force in so many lawsuits. Emotions are what's involved here. People get angry, people get their feelings hurt, people are suspicious. Trust goes out the door. You name it, those emotions are there. So emotions are incredibly important to the success of a business when you have owners, co-owners, partners in a business. And so what I tell people is that when you have an agreement in writing and everyone understands where you sit, there tends to be this feeling of, okay, it's all good. We're covered. I'm covered. You're covered. We've talked about this. It's good. I feel comfortable that I know what the risks are. We've covered things. We've got rules for how we kind of behave with each other. And it sets the tone for how that business is moving forward. And it also gives people the, I want to say security, perhaps that's not the word, confidence maybe, to come forward when something's not working very well. So when you have an unhappy business partner, this is what happens. And I can tell you some stories, and of course I'm going to change names. I'm not going to name clients on here or anywhere because it's their private business. But you know, I'm their business attorney, so I hear the inside stories and I hear what they're telling me, and this is what happens. When I have a business business partners that don't have an agreement in place, everything's uncertain. And, you know, they say, well, I'm not really sure. I think so-and-so might, you know, I think Jim might be trying to do this. And, you know, Jim might say, you know what, I don't even know what Don is thinking because Don doesn't tell me what he's thinking. And I'm trying to move in this direction. It feels like Don's going off in another direction, and everything is just uncertain. And so then Don is unhappy and wants to leave, but doesn't know what the process is. I'm actually dealing with this right now with one of the clients. They don't know what the process is. How do I leave the company? And the conflict. And then Jim is uncertain because now Don wants to leave. And does this mean the business has to shut down? And, you know, are they going to lose everything they've built for so many years? And, you know, do either one of them get the money out of it? I mean, what's going to happen? You know, how are they supporting their families moving forward? And so it just becomes really difficult. Whereas flip it to other situations where other clients have had an agreement in place, and then it's just to pick up the phone. Hey, we've got a situation and I want to buy out my other partner, and I'm going to call him Bob. And Bob and Mark want to split up, and Mark calls and says, hey, I'm buying out Bob. Here's the deal. And all they have to do is follow the steps in their agreement, and it's easy. They both know what's expected. There's no uncertainty, and off Mark goes. He's out. Bob carries on. Business doesn't suffer. Everybody's happy and can go their own separate ways, and they don't have to be in a situation they don't want to be in anymore, without all the conflict and the uncertainty and things kind of exploding. And so that is a great benefit to having an ownership agreement. And I will tell you, me personally, I see both sides. I see the pros and the cons of having business partners. Obviously, I do not have a business partner, nor will I have a business partner. And that is because I've had partners before, and I feel that for me, the cons outweigh the benefits. And so while I do have strategic partnerships with others, I don't have a true business partner inside our firm. I'm not saying I would never will again, but I can't foresee that that's going to happen for me. But I have had clients who it's been incredibly successful. And I do see the benefits of having other people share the responsibilities and bringing their strengths into the business. And when you can have a relationship and build a relationship where it works together, like the pieces of the puzzle really work together well, then it can benefit the business very much. The flip side of that is everybody always needs to have an out. If people feel stuck, they are going to start turning sour. And so you don't want any sour business owners. So everybody always needs to have choices to make. And so to stay or to leave always needs to be an open door. And that door needs to be very clearly outlined so people feel comfortable and secure in their choices. And that's when things go very smooth for the business, and the business doesn't, you lose so much altitude and then try to climb back up again after the ownership changes. So for you, and I know many of you are single owners and are thinking maybe perhaps about having a business partner. This might be a way that you can use the audit sheets to trigger whether you want to have a business owner, or in the future, maybe right now you're not thinking about it, but in a year or two, somebody might approach you, or you might approach somebody else, and you can pull this out and think about, okay, these are the issues that I need to think about when bringing on a business partner. So your audit sheet is about 3 pages, and it has all these questions on it. So I'm going to give you just a little instructions for when you take off and do this. You will need to answer each question in 5 words or less, and there's a reason for this. So I've not given you a whole lot of room to answer. I really want you to think through your answer and not ramble. I want you to distill it all down to very simple words. How long have you known your business partner? Not the whole history. Has it been 2 years? Then you put 2 years. If it's been 2 days, then that's what you put here. And then over here on the right-hand column, as you probably have seen by now and realize, I've always got this action item thing going on where, okay, is this an issue? The action item might be for how long you've known your business partner. It might be, then now is not the time. I've just met you 2 days ago. Let's give this some time and revisit this in 6 months, or let's do something else together first before we become business partners. Let's think about, what other kind of strategic project we can do together and work together on something before we jump in and become married. Remember, it's as entwined and official as a marriage. And so if that's an action item for you, then you would flag that. How long have you been in business together? So your audit sheet goes on for almost, I think it's 3 pages. So go through those questions, figure out if this is something that you truly want to do, and you can use it for each time you decide if you want to have a business partner. All right, so that's your owner relationships section. Any questions so far? Anybody have anything they want to ask about owners before we move on to the next topic? I know if we were sitting together in a room where we normally would be, you could just ask me. So don't be shy with technology. Just pretend it's just raising your hand and asking me a question. I'm happy to answer. Okay, seeing none, we'll go ahead and move on. So we are still in internal relationships. We talked about owner relationships, and now we're going to talk about worker relationships. And so even if you are a single owner business, chances are you are not the only person that works in your business. You either have maybe some employees or maybe a contractor or multiple contractor. When I talk about workers, I'm talking about those who serve your clients or your customers. Who does the work? And so you had some homework of your own that you were asked to do if you attended the last week's session, and it looked like this. So I wanted you to list your workers. I wanted you to list your employees, and then down here I wanted you to list your contractors. And hopefully you've done that so that you have an idea, and maybe you have nothing on this list yet. Maybe you're thinking about it, or maybe you have 1 employee and 5 contractors, or vice versa, 5 employees and 1 contractor. It doesn't really matter at this point because we're going to talk about both types of workers. I just wanted you to be thinking about who you have on your staff so that you have the ability to think about these issues in terms of actual people and actual situations. And that way it helps a little bit with applicability of this information. All right, so let's talk about it first. Employees and independent contractors. There is a difference. And you will need to classify them one way or the other. So they are either employees or they are independent contractors. They're never both. So some people call employees, some people call them W-2s. And the reason they call them W-2s is because employees are actually run through the payroll for a business, and the business withholds some of the tax money from the employee and pays it to the government. The business also pays some of their own money to the government as in taxes, employment taxes. So the employee pays half, the business pays half, the full amount goes to the government. That's on employees, and the employee then receives a Form W-2 at the end of the year showing how much money they had earned, how much taxes have been submitted to the government in their name. That's an employee, or some people call them a W-2 employee. Independent contractors are totally different. Independent contractors are not put through payroll. So independent contractors are paid a lump sum, and then the contractors are responsible for submitting their own taxes. So the business does not withhold any money from the independent contractor. From their pay, the business doesn't withhold any and give it to the government. The only thing the business does is pay the independent contractor, and then they say, peace out. I'm not responsible for your taxes, you are. So sometimes businesses think that this is beneficial because, hey, all I have to do is pay the independent contractor and I don't have to worry about paying any taxes, because the contractor pays the full amount of the taxes, 100% of the taxes. The employee, I'm going to back up here a minute, the employee only pays half and the business pays half. Contractor pays 100%, business pays 0. So you can imagine from the business's perspective, they want everybody to be an independent contractor, right? Because then you don't have to have the headache of withholding taxes, submitting them to the government, paying half of the taxes, and then having all that liability that comes with keeping track of all those dollars and everything. And that liability isn't small, admittedly. So businesses are naturally inclined to want to do independent contractors. If it was up to most businesses, they would have everybody as an independent contractor because they don't want to be responsible for the taxes. But the problem comes in is that all of these things only apply to employees. So unemployment. So each state has their own unemployment fund. So all the businesses pay into it. I pay in, my business pays into it. Your business pays into it. We have this fund that the state manages, and then that fund pays for people when they file for unemployment benefits. Well, that only happens for employees. Independent contractors, we're not paying into that fund for independent contractors. Independent contractors cannot apply for unemployment if we fire them. And so states have an incentive to say, okay, who's an employee and who's an independent contractor? The other thing is the benefits. So if you're an independent contractor, you don't have benefits. There's no paid time off. There's no holiday pay. There's no insurance. If you offer insurance or any business offers insurance, there's no workers' comp. That's a big one too. If somebody gets hurt on the job, there's no workers' comp for independent contractors. There is for employees. And then we've already talked about payroll taxes. So all those differences come into play between employees and independent contractors. It's just a completely different beast. Completely different colors, shapes, sizes, even though from your point of view as a business owner, they look like they could be really close. Like, so I don't know. I mean, this person does this and they're an employee. They do the same thing and they're an independent contractor. I mean, like the line seems very blurred from a business owner's perspective. But from the law side, they are completely different and very, very clearly treated differently. And so this kind of creates problems sometimes because who's regulating this? Well, the IRS is regulating this, and I'm giving a website here, and IRS has this, is it an independent contractor or an employee kind of questionnaire. And the IRS is concerned. Why? Because of payroll taxes. Because when you as a business submit payroll taxes, then the IRS is getting their tax money, right? They have to rely on the independent contractor to submit their own taxes. And so the IRS obviously has an incentive to say what's going on here. The US Department of Labor. So this is federal. Okay, this is federal. This is the whole national government. This is the Washington, D.C. side of things, not the Florida side of things. US Department of Labor governs how employees are treated and the benefits that they receive. So think about discrimination claims, sexual harassment, ERISA, retirement benefits. All those things apply to employees. They don't apply to independent contractors. And so the US Department of Labor is the one who oversees these types of claims. And so they have an incentive to regulate whether or not someone is an employee or an independent contractor. And then you've got the Florida Department of Revenue. So this is a state agency, and this is the kind of the IRS of Florida. The state of Florida has its own Department of Revenue, and they collect taxes as well. And the unemployment is one of their big things. And so the unemployment taxes that come in, and then there's some workers' comp things rolled around in there too, but mostly it's unemployment taxes. And some other types of business taxes. But for this issue, it has to do with employees and independent contractors. So they are concerned with how do you classify your workers. So all of these agencies are kind of poking in, saying, what are you doing? What are you doing? What are you doing? How are you treating this worker? What kind of worker is this? So let's talk about that. Oops, I clicked off of my PowerPoint, didn't I? I clicked on that and it showed the website. So when you get it, you can click on it and it'll show you. All right, so the US Supreme Court, this is another one that regulates what happens with independent contractors and employees. So you can imagine that this is such a muddy area that there's been so much conflict over the years that all these court cases have kind of come and they've made it to the Supreme Court. So we're talking about the US Supreme Court, then not just Florida Supreme Court. So the US Supreme Court all over the country says there is no single rule or test for determining whether an individual is an independent contractor or an employee for the purposes of the Fair Labor Standards Act. So this is a Fair Labor Standards Act. I don't want to get too deep into it because employment law is hugely complicated, but it governs a lot of things about employees. And so the US Supreme Court is saying there's no single rule or test. What does this mean for us? Well, it means that it's the total activity or the situation. So they're not going to say this like bright line, black or white, check the box, yes or no answer. It's going to be an attorney's favorite answer, which is it depends. It depends on the activity. It depends on what the worker is doing. And it depends on the situation that you create as the business. So there are certain factors which are immaterial, unimportant, in determining whether there is an employment relationship. So these are the things that are unimportant. The place where the work is performed, unimportant. The absence of a formal employee agreement, unimportant. Whether an alleged independent contractor is licensed, unimportant. These are not considered in having a bearing on whether there is an employee relationship or an independent contractor relationship. So if someone is licensed, they could be either, doesn't matter. Place where they perform the work, doesn't matter. Whether there's an employment agreement, so you can't get around it by saying, you know what, we didn't have an employment agreement, so therefore they're an independent contractor. Doesn't matter. So the Supreme also says, here's the kicker. This one I see a lot. Almost all of my clients say this to me, but I don't pay them by the hour. They don't track their time. That doesn't really matter. The time or mode of pay does not control the determination of employee status. So you could have an independent contractor that you pay on a monthly basis. The IRS or the Department of Labor or Florida Department of Revenue could still come in and say that they're an employee based on what they do and the situation you create. Okay, so what I'm trying to explain to you is some things that people commonly think will determine whether someone is an independent contractor or whether they're an employee. Those things are myths. That's not really what controls. So here's the things that the Supreme Court has said. These are what's important. Number one, the extent to which the services rendered are an integral part of the principal's business. In other words, is this the primary thing that you work on? This one is a little bit of a controversial one. I'm going to just admit that to you right now. This one is in flux. It's changing somewhat. And so this one basically says that if a worker is doing the primary function of your business, then it tends to be an employee. And there are some circumstances where that may not be the case. The permanency of the relationship. Is this temporary? Is it long-term? Is it years and years and years? Is it ongoing? Is there never anticipated end? Because normally when you have an independent contractor, there's some sort of anticipated end, right? It's, at some point the relationship's going to end or the project's going to be complete. So they look at that. The amount of the alleged contractor's investment in facilities and equipment. This is whether if a worker is an independent contractor, did they buy their own stuff? Did they go out and buy their own equipment? Do they have their own vehicles? Do they have their own office? Do they have their own stuff? That's a factor. The nature and degree of control by you, the business owner. Do you tell them how to do it, where to do it, when to do it, and all of the instructions? Then that's a level of control that they're going to look at and say, hey, you control this person, this worker. Control factor goes towards employee. And then the alleged contractor's opportunities for profit and loss. So does the contractor operate like their own independent business? Do they have the ability to make a profit, or do they have the risk of suffering a loss? And that is an important part of being your own business. So an independent contractor is having their own business. So do they make a profit or do they make a loss? I mean, that risk there has to be there for that business to function. Whereas if somebody's going to get paid for work performed, no matter what happens, that's more like an employee, right? There's no risk of loss for an employee because they're going to get paid for whatever work they do regardless, or they're going to maybe not have expenses and have to come out and pay for new tools or whatever that might be, so that the employee, everything's covered. The employee just walks away with a paycheck. That's always a benefit. Whereas the independent contractor has to cover their expenses. They have to have supplies and materials. And so maybe they don't get paid as much to cover what their expenses are. And then they would be subject to a loss. The amount of the initiative, judgment, or foresight in open market competition with others required for the success of the claimed independent contractor. All right. Translation, what this means is if it's a contractor, are they openly competing in the market for the business? So is it something where, as a business owner, you shopped around and this is the best bookkeeper you can find? Well, a bookkeeper for me is an independent contractor because I did shop around and find a bookkeeper. I could hire an employee that's a bookkeeper. I could. And that person would be an employee because they would use my computers, They would be in my office. They would be using my supplies. They would be working when I tell them to work, reporting to work at a certain point in time. So my bookkeeper could very well be an employee. But my bookkeeper is an independent contractor. And I shopped around for bookkeepers, and there is a market for bookkeepers. And I did find multiple ones and chose the one that I wanted. And so that bookkeeper then, regardless of whether or not they just work for me or whether they work for 10 other law firms, that bookkeeper could be considered an independent contractor. They use their own computer, their own supplies, their own facilities, their own equipment. And I'm not controlling when they work and all of that kind of stuff. So the type of work that's done can be in either category. It's the second part of that is the situation that you set up for that worker will also determine whether or not that bookkeeper is an independent contractor or an employee. Now, keep in mind, the bookkeeper is not doing legal work. So they're not doing number one. They're not an integral part of my business. I'm not offering bookkeeping services to my clients. We're offering legal services to our clients. And so the legal services are an integral part of my business, but bookkeeping is not. That's my business stuff. So I can farm that out. I can either hire somebody inside to do it as an employee, or I can farm it out to an independent contractor. So depending on the activity and the situation that you create is what tells whether someone's an independent contractor. The decree of independent business organization and operation. What this means is, are they set up as an LLC? Are they set up as a corporation? You know, even if they're set up as a sole proprietor, do they have a DBA, a fictitious name? Do they have an EIN? Do they have independent bank accounts? Are they setting it up and running it as an independent business? That leads in your favor if you want to call them a contractor. So the IRS, keep in mind, that was the Supreme Court of Florida. I'm sorry, this US Supreme Court. Okay, that governs the whole land. The Internal Revenue Service operates by their own rules. That's right, their own rules. And so they have their own set of what's important. So here, let's talk about the IRS. And you're going to see some crossover, so it's not going to be all that different. So behavioral, what kind of instructions are given? This is all a control issue, right? Degree of instruction. You know, do you train? Do you educate? Do you have them follow your procedures? Do you give them forms? Do you are they working inside your systems, or are they working in their own systems? Evaluation, do you give them performance reviews? Well, that's an employee, right? An independent contractor, you wouldn't necessarily give them a performance review. Training, we talked about. Financial pieces, if a contractor should have a significant investment in their business? You know, did they have to put money up for buying equipment or supplies? You know, do you reimburse expenses or not? Will employees get their expenses reimbursed? Independent contractors may not get their expenses reimbursed. It depends on the situation. Is there an opportunity for profit and loss? We talked about that one. Are there services available? Are the contractors' services available to others? In other words, do they work just for you, or do they work for other people too? And what is the method of payment? Do they invoice you? This isn't like a check the box yes or no issue. It's just part of the whole analysis. I mean, I like when our clients have independent contractors, I like for there to be invoices, because it shows this is independent contractor. It's an independent business. They invoice for their services. Type of relationship. Independent contractors need to have an independent contractor agreement. Employees don't have to have an employment agreement, but independent contractors need to have an independent contractor agreement. It says important things to it, and it needs to be there if that worker is going to be a contractor. Are there employee benefits? And I've seen this happen. This one, I see people say, oh, it's a 1099 employee. There is no such thing as a 1099 employee. A 1099 is an independent contractor. An employee is an employee. So there is no 1099 employee. That's trying to have the best of both worlds. Not going to happen. A 1099 is an independent contractor. An employee is a W-2. So employee benefits, I see that, independent contractor, I'm going to give you 2 weeks vacation. There is no benefits for independent contractors because they are their own business. They set their own terms. They set the times that they're going to work. You can set the times for employees, but you can't set the times for independent contractors. So if there's employee benefits built in, like time off and expense reimbursements and all those other kinds of things, then you're leaning towards the employee side of things. And then the permanency of the relationship. If it's just like open-ended, ongoing, that tends to be more like an employee situation than a contractor situation. It doesn't have to be, but it tends to be. And then services provided as the key activity of the business. So that's like my example of bookkeeper versus legal services. So the third authority that governs what these relationships are like, Florida Department of Revenue, has its own rules. And they're similar, but not exact. And for Florida, if you intentionally misclassify a worker, it is a felony. That is a criminal charge. So the state of Florida takes it very, very seriously. So if you say, I'm going to classify them as an independent contractor because I don't want to deal with the taxes, I don't want to deal with the liability and everything else, but yet you treat them like an employee, that intentional misclassification you could be charged with a felony. So be very aware that while it seems easy and it seems like no one's looking and I'm just going to treat this worker as a contractor, there are serious repercussions and there are many, many, many people looking at this. You may not even know they're looking at it because they see the documents that are submitted. So they don't even have to contact you and say, I'm looking at you. They just look at it. So there's eyes everywhere on this. Be very aware of this. This is not something that's just kind of, set to the side and under the covers. They are looking at this. And for some industries, they are looking at it harder than others. So just make sure that you pay attention to this classification when you hire workers. So Florida Department of Revenue, what is their test? Number one, the extent of control. So again, the business, how does the business exercise control over the details of the work? The business can control the employee. The business should not be controlling the contractor. That's the general rule. Now, every situation is a little bit different. So my bookkeeper, I do have some control over my bookkeeper because I don't want her to label some expenses one thing. I want her to label it something else. So I say, label this as a networking expense. Label this as a marketing expense. Whatever it is, I'm telling her how I want it done, but I'm not telling her when to go in and do it, who does it on her side. I mean, they've got, many employees on there. I don't know who's going in doing it, nor am I saying this person has to do it at this time. So it's the extent to which you are controlling. If you're all controlling everything, then that's employee. If you're just controlling a little bit, you can probably get away with it on the contractor side. Whether the one employed is engaged in a distinct occupation or business, such as a bookkeeper, that is a distinct business. Whereas a receptionist, you'd probably have a really hard time getting away with classifying a receptionist as an independent contractor because that is not a distinct occupation or a distinct business. That is typically something that is done as an employee. Whether the work done in a certain locality is usually done under the direction of the employer or whether a specialist without supervision. This just means this has a lot to do with some trades and some licensed people, but basically what it's saying is in your area, what's normally done this way. And there are some circumstances, which I'm running out of time, so I don't want to go too deep into this, but it's really looking at how is it done? How are other people doing it that are around you? The skill required in the particular occupation, whether the employer or the worker supplies the instrumentalities, for example, the equipment, vehicle, materials, tools, and the place of work for the person doing the work. We've talked about that one. This is a common one in all three tests. The length of time, again, we've talked about that one. The method of payment, whether by the time or the job. whether the work is a part of the regular business of the employer. So you see, these are common themes. All three agencies are looking at very similar things. So you need to look at how you're set up with this, whether the parties believe they are creating the relationship of an employer-employee. Okay, so here's the kicker. Let's say you hire an independent contractor, and it's very clear you're hiring them as an independent contractor. And they say, yes, I'm hired as an independent. I know I'm not an employee, but you don't have an independent contractor agreement. Later, you fire them. And what's going to happen? They're going to go and they're going to say, I thought I was an employee, and therefore I get unemployment benefits. And they're going to file with the state of Florida, and the state of Florida is going to say, well, wait a minute. We don't have any unemployment payments from this person, from this business. And so they come looking and they ask you, why haven't you paid any unemployment on this person? And you're going to say, well, that wasn't an employee. That was an independent contractor. And they're going to say, well, where's your independent contractor agreement? Oh, well, I don't have one. Well, the employee, that worker, thought they were an employee. That's what they're saying. And now they're going to be, because they want unemployment. And then the state could say, no, that was an employee. You should have been treating that as employee. And then you'd have back taxes. You'd have probably some fines and penalties. And it's not pretty. And then whether or not the hiring party is or is not a business. So we talked about this one also, whether they're a sole proprietor or a LLC or a corporation. So that's a lot of information, right? What seemed like a fairly simple, easy decision now doesn't seem so fairly easy or simple, does it? So number one, protecting your business. How do you classify that worker? And you're going to go through and you're going to look at all the things we just talked about for each individual person you put on your homework list. Whatever category you put them on, pretend it doesn't matter. You're going to go through this analysis for each one, and you're going to say, does this fit? Is this the right label for that worker? And then after you've done that, the classification, I want you to also assess your confidential business information. Somebody asked earlier about a confidentiality and non-competes and things like that. We're going to talk a little bit about that for the last few minutes we've got together today. You're going to assess whether your confidential business information is given to that worker. And if it is, whether it's your confidential information, your business confidential information, you should look at having a non-disclosure agreement. You might look at having a non-compete, maybe even a non-disparagement, which means once they leave you, they can't talk bad about you. A provision of specific training. If you've trained that worker, most likely it's going to be an employee, because you don't train contractors, you train employees. And so a non-compete for that employee might be applicable, might be appropriate, because you've trained them, therefore they can't take your training and go use it to the benefit of some other business. So a non-competition might be a good thing. Customer acquisition. How do you protect your clients? What if they go and they solicit your clients and try to take your clients with them? Or maybe they don't want your client for them. Maybe they're just trying to take your client for some other business and solicit it for on behalf of the other company. That would be problematic. Referral sources. How do you protect your referral sources? The people who who refer you business. That could be a non-solicitation type of situation. If for employees, true employees that you've classified as employees, you've got HR compliance. All the different things that you've got. Your Form I-9s and all your new hire reportings for the state of Florida. Your employee policies. All of those things are part of this part of the audit of your business. So this section of your audit is really big. It is a big piece of most small businesses that have workers. It's a big piece of it. And then the other one that I want you to keep in mind is if you have employees in multiple states, you're going to have more issues to discuss. So you're going to have taxes in those states. You're going to have to register in those states to do business, all those kinds of things. So even if you have a work from home employee that is at home working for you, but they're in another state, you're going to have issues. So you have to be aware that that employee in that state, you're now going to have to register in that state and submit employment taxes for that state. So that was protecting your business. This is protecting your client. And there is a difference. So protecting your own business, when you hire people to work for you, whether they're contractors or employees, confidentiality, non-solicitation, non-disparagement, all those things that we talked about are protecting your business. But your workers have access to your clients and your customers because they're the ones that are doing the work. And so how do you protect your clients as well? Because it is your job to protect your clients too. How embarrassing would it be if you had a worker that turned around and used something they learned from you or your business and then harmed your client? Posted something on social media, said something to them, whatever it would be. That would be really detrimental to your business and your client. So here's what you need to think about with protecting your clients. Who has access to clients' information? Maybe your receptionist doesn't have access to your client's information, but your bookkeeper does because they see what your client is paying and they see what your client is paying for. So, or your customer. And this could be any type of worker. I keep using bookkeeper because it's an easy example, but it could be anything, any type of information, not just financial. It could be anything about that client's business. And then, so your duty is to have that worker sign a confidentiality agreement. And that is a bare minimum, in my opinion. Any employee, any contractor needs to sign a confidentiality agreement because that is the bare minimum of protecting your business and your clients. And so that could be a standalone agreement. It could be in combination with all the other things we've been talking about. Physical harm. And by this, I mean intentional or unintentional. So let's say we've got several clients who go into people's homes. So we have all different kinds of businesses that go into people's homes to do things for them. Inside homes, there is a chance of harm, whether it's property harm or harm to bodies. It could be even a chauffeur's business. It could be a driving vehicle. It could be equipment. It could be anything, intentional or unintentional. You know, if somebody gets angry, an employee gets angry and throws something, punches somebody in a restaurant, it could be anything. Any type of contact that the worker has with clients and customers. Business representation. Again, this is the authority. What do people have? They walk into some business and say, well, I work at so-and-so and I'm there such and such. And I'm telling you, you've got to do this. That's as a representative of your business. They represent your business in the community. What are they doing in the community? Are they embarrassing you? Are they saying things that are inappropriate? Are they committing illegal acts? I mean, these are questions you need to ask. And when you hire people, you need to be thinking about, because this is something that is really important for your business representation and your business, but also with your client, because, you know, are they talking to your client on your behalf? Are they saying to your client, this is what we think you should do? Then your client needs to make sure, or you need to make sure that that's the information that your client should be receiving. Ownership of creations. This is for people who maybe some creatives that create things. So we've got some interior designers, some architects. We've got engineers as clients. We've got all kinds of different we've got photographers, we've got graphic designers. They're all creating things. They're creating things, and that's intellectual property. That IP means intellectual property. So who creates them? So when a client hires your business to create a website, who owns that website? You don't. You own it if you create it, but if the client is paying you, you should be giving that ownership to your client. But the problem is you personally are not creating it. Your workers are creating it. So if the client thinks they own the website, but your employees created the website or your contractors created the website, then that ownership needs to come from the contractor to you and then to you to the client, so that the client ends up getting what they paid for, what they think they're getting. So here's the audit sheet for your workers. It is pretty extensive. And again, you've got, questions, answers, and then your action items. So the questions here, there'll be a section for employees. So you go through, do your employees have contact with your customers or clients? So this is, again, this is spotting the issues or the areas where there could be problems. And so you're going to go through here and you're going to answer these questions. And then you're going to decide for yourself, for your business and your situation, whether that could be a problem for your business. And then if it is, then I want you to check that action box there for you to circle back to and deal with. So all of these questions, then you'll have a section for independent contractors. This goes through some of those things. It doesn't necessarily mean that this is the only thing I want you to do. I do want you to do this audit sheet, but I want you to also go back through your homework list, and I want you to look at all the rules we just discussed for how someone is classified, whether they're classified as an independent contractor or whether they're classified as an employee. And I want you to think about those rules as they apply to that person and do it individually, one person at a time, one worker at a time, because one worker might need to be a contractor and one worker might need to be an employee. And it's just on a case-by-case basis. So don't think that they all are treated the same. All right, so that's your audit sheet for worker relationships. I do want you to go back through those notes and the presentation and take a look at those websites and look to see whether or not your workers are classified correctly. If you don't have workers yet, when you go to structure that position or hire someone, whether as a contractor or an employee, keep these things in mind, because this is one of the areas where small businesses get hung up pretty frequently. And like I said, there's certain industries that are looked at more than others. Believe it or not, my industry, the legal industry, is looked at pretty hard. Technology industries are looked at pretty hard. Other types of industries that hire contractors, cleaning industries. There's several of them. If you do an online search, it changes over time. It'll come up with some of the industries that are being looked at more heavily right now. In any case, even if you are not on that hot list, and you still need to make sure that you are following the rules and doing it correctly, because this is an area that you can avoid problems easily. Just keep them from happening altogether is by classifying them correctly. And then the other things we talked about, such as the confidentiality and the non-competes and the non-solicitations, those things are protections. If a problem does occur, then you've got something in place to minimize those problems and your HR compliance and things like that. All right, well, that is the end of my presentation for this internal topics. Do you all have any questions for me? Let me see if I can get to that screen to see if there was any. Okay, looks like Jackie put the link for the online classroom in the chat. All right, let me go over to the question and answer. It looks like Jackie's answered one. It says, do you have these forms available for us? I have the audit sheet. I'm not exactly sure what forms if you're looking for contract forms, no. That needs to be something that you do on an individual basis, and that needs to fit your circumstances. So there's no forms for contracts. There's the forms for the audit sheets. Should I use an NDA when talking to potential partners about my ideas for collaboration? What things can I do to not intimidate them when I present an NDA before the meeting? Okay, so that's interesting. You say potential partners about my idea for collaboration. Do you mean like owners, like maybe partners as like business partners? Angela, do you have so sometimes people talk about joint ventures where they're not business partners. And so that question is a little bit, can be different. Okay, so joint ventures is your question. So not really talking about business partners, you're talking about maybe doing something together. I mean, I don't think NDAs are necessary unless you're going to be telling them secrets. So, ideas, ideas could be secrets, but typically ideas are not protected because they're ideas. And so, anybody can have an idea, but if you do something, like if you've got an idea to create, let's just say you have an idea to create a product, but it's just an idea right now. You don't have a design for it. You don't have a plan. You know nothing about manufacturing. It's just an idea. You can't really protect that. The law does not protect ideas, because what would happen then? People would hoard ideas, and maybe if you hoard it, nobody knows it. The idea never comes to life because that person has kept it secret. Whereas, if you've gone to the lengths of developing a product design and you've got some sort of manufacturing things going on, then the product design is protected, and all the preparation you've done, whatever you've put into writing or you've put into some sort of physical medium, that means that is protected. But the idea in your head isn't really protected ever. So, if it's something that you don't want people to share, then I would say probably an NDA would be appropriate. It's hard to say, like you said, it's a little intimidating to, pull out an NDA right off the bat. It depends on the level of sophistication too of the other person you're talking to. If they're used to like business and they've been in business for a while, that's not going to intimidate them because they're a little bit more sophisticated and they know what an NDA is. An NDA is a non-disclosure agreement, which means that I tell you something, but you can't tell anybody else. And NDAs are technical in nature. I read one for a client this morning, and I said, wait a minute, this isn't even the party you're telling. So the party that's on the NDA is not the party you're telling. You're telling these people, and the NDA, these people signed the NDA. These people never signed the NDA, and these people are the ones you're telling. So all the pieces have to connect together for that to work. So, I've seen NDAs that aren't connected well, and they don't really do you any benefit. So I would just say, think about it. And as far as presenting the NDA to them, I would say, explain why first and say, look, these are things that I have developed in my business that are not commonly known, and they have value to me. And before I tell you what they are, I want to make sure that they stay confidential and that they don't go any further than this room. And if they're not okay with that, then that's probably not a good fit, and you probably shouldn't move forward with it. And you give them the NDA. You don't expect them to sign it on the spot. Give them a chance to read it. Take it to their attorney if they want to. Don't be intimidated by that. If they say, oh, I'm gonna take it to my attorney, fine, good. That's a good thing. Take it to your attorney. Understand what you're getting into so that when you sign, you know what that means. I hope I answered that question adequately. Okay, so Marcus, non-compete, NDAs, non-disparagements. What does that mean? Was there a question there about non-compete, NDAs, non-disparagements? I'm not sure what the question is. So I'll just talk about them. And a non-compete is different than a non-disclosure, is different than a non-disparagement, is different than a non-solicitation. So what that means is that they can all be combined into one agreement. They can all be standalone agreements depending on the situation. So, you know, non-compete says you can't go compete, you can't work for a competing business. A non-disparagement says you can't say bad things about me. And then a non-solicitation says there's two types of non-solicitation, actually three types. One is you can't solicit my clients. So even if you don't go work for a competing business, you know, I'm a roofing company and you go work for a flooring company, you can't come and solicit your clients. And then, you know, if non-solicitation of clients, non-solicitation of employees, meaning you can't poach my employees, my workers, who I've invested training and time into, and then my referral sources, you can't go and poach my referral sources. And that one's harder to do. It has to be, that's only for certain situations. That one tends to be more of a non-circumvention, which means that I'm the middleman, you can't go around me. And so that's usually what we do for referral sources with solicitations. Okay, so those were the forms you were asking about, blank versions of. No, there are no blank versions of that. They are different in every circumstance. And I would strongly discourage you from finding forms online for those, because non-competes, for one, are very tricky. They're very state specific. All of them are state specific. And so one form cannot possibly fit all sizes. I think we talked about this maybe in the very first class. Somebody had asked me about, or maybe it was last week, where I asked about the Office Depot forms or something like that. And I said, when somebody drafts a form and puts up and makes it so that all people can use it, then it's too general for anybody to use, because no form could possibly be written well enough, specific enough for all businesses to be able to use it. So any form that is going to be out there is going to be so general that it's not going to be worth much, because it's not going to be specific to you or even probably what you would need. So I would hesitate, especially for those, because there's a lot riding on those forms. There's a lot riding on those contracts, especially the non-competition one and the non-solicitation one. So so those are a little bit too tricky to try to grab a form online for. All right. I see we are out of time, and I think that I've answered all the questions. Jackie, correct me if I'm wrong.
Yes, I think we have seen all the questions. Marcus says understood. Thank you. So yes,
You're welcome.
Thank you all very much. I'm going to stop today's recording. You have the link for the online classroom as well as homework.